Well, this week seems to be motion in limine week, since besides the Karen Reed case and all those motions in limine, there is a motion in limine filed in the Donna Adelson case. Yeah, by the defense for Donna Adelson, they filed this motion in limine, and it actually brings up some very interesting issues. So let's go through it. We'll pull it up, and we'll talk about the Donna Adelson case. So here we go. We've got this motion. Starting off here, Mrs. Adelson has been indicted in this case with 1 count of first-degree murder, 1 count of conspiracy to commit first-degree murder, and 1 count of solicitation of first-degree murder. The state has listed as Exhibit 60 divorce filing, indicating their intent to admit the entire court file in Adelson versus Markell. This is the divorce filing between Dan Markell and Wendi Adelson. By this motion, Mrs. Adelson moves to exclude and or limit State's Exhibit 60. Although Section 90.2026 Florida statutes permits a party to ask a court to take judicial notice of court files, the contents of the court file and the documents contained therein must still be admissible. The contents must be relevant. Additionally, documents which contain hearsay are still inadmissible. So if there is something in this divorce file which would constitute hearsay, well, guess what? It cannot come in the Donna Adelson case. In Stoll versus State, the court held that although a trial court may take judicial notice of court records, it does not follow that this provision permits the wholesale admission of all hearsay statements contained within those records. We have never held that such otherwise inadmissible documents are automatically admissible just because they were included in judicially noticed court file. To the contrary, we find that documents contained in a court file, even if that entire file is judicially noticed, are still subject to the same rules of evidence to which all evidence must adhere. The divorce file contains over 560 pages. It is significant that Mrs. Adelson was not a party to the divorce proceedings. So we're going to see why that is significant. The fact that Donna Adelson obviously was not a party to that divorce action. So we're going to see why that actually is very relevant in their argument. There can be no credible argument that the vast majority of documents have any relevance to this proceeding. By way of example, and they bring a whole bunch of examples of the court file, of the divorce file, that should not be admissible and have no relevance. The only significance the undersigned can fathom is that the state desires to use the size of the divorce file to support their false narrative that the divorce was a bitter custody battle. And now if you take a look at the footnotes, which I always like to do, not 2, but 3 here, rather, an objective review of the court file reveals that it is simply a dissolution of marriage between 2 well-educated professionals involving minor children and assets. Neither party alleged abuse or neglect such that one would have a basis to seek majority time sharing. So this is not a bitter custody battle. This is just 2 professionals who simply decided to get divorced. These documents, which comprise the majority of the exhibit, do not survive a relevance analysis in any way. In seeking admission of the divorce file in previous trials, the state has asserted that the statements contained in certain filings go to motive of the defendant then on trial. So this is one way to get around the hearsay problem. And obviously, when there is a hearsay problem, you have to address it. So what is the exception? Well, it goes to the motive. It goes to the state of mind of Donna Adelson at the time when this murder was committed. Although such an argument could overcome the relevancy issue addressed above, the state must still establish their admissibility as either an exception to hearsay or as non-hearsay. Regardless, the state of mind exception to the hearsay rule does not extend to the admission of the divorce file in its entirety. So even if you want to argue that some of the documents are relevant and should be admitted, but still a lot of this 560 pages in this file should not be admitted. Significantly, the state of mind of the declarant is the subject of the exception in Section 90.803 Florida statutes, and it applies solely to the declarant's state of mind rather than the state of mind of the defendant. So when you're talking about hearsay, we're not going to offer this hearsay for the truth of the matter asserted, but the person who made that statement, we want to show that person who made the statements his state of mind. Now, obviously, that Donna Adelson, if she's not the declarant of some of those statements, so then you can't use that to show her state of mind. Continuing on. For example, in Bailey versus State, the defendant's first-degree murder conviction was remanded for a new trial because hearsay statements of the deceased victim, which tended to establish a motive for the alleged crime, were obviously offered to prove the state of mind or motive of defendant, a purpose for which the hearsay exception created by Section 90.03 Florida statutes does not apply. So that was a statement by the victim, and that statement was offered in the trial to prove the state of mind of the defendant. So that was not the defendant's statement, and yet it was the statement of the deceased victim, and that was offered to show the state of mind of the defendant. So that's why they said that there has to be a new trial. With respect to Mr. Markel's March 26, 2014 counter motion for enforcement, the motion contains 8 specific requests. Only one of these requests apply to Mrs. Adelson. Namely, the motion identifies statements allegedly made by Mrs. Adelson to or in the presence of her 3- and 4-year-old grandchildren. So you'll remember that this was in the motion of Dan Markel in the divorce proceeding, in which he said over statements that his children said that Donna Adelson said to them. Statements purportedly made by Mrs. Adelson are admissions. However, statements made by her grandsons to Mr. Markel are hearsay. So you want to say, okay, a statement of a defendant is an admission, and therefore that goes beyond that's a hearsay exception. Okay, that's fine. But these are statements made by her grandchildren about what she said. Those are not admissible. That's hearsay. Those are not admissions by Donna Adelson. You're trying to introduce statements of her grandchildren. The statements in Mr. Markel's court filings are also hearsay. Section 90.805 Florida statutes requires the proponent of the statement to assert valid exceptions for each level of hearsay to render the statement admissible. So this is Dan Markel's court filings. So that's obviously not a statement that Donna Adelson made. Those are considered hearsay. And then you have the statements of the grandchildren, which also are hearsay. So that's two parts of hearsay. With respect to the alleged statements repeated by the 3- and 4-year-old grandchildren to Mr. Markel, and which Mr. Markel placed in the court file, there are 2 levels of hearsay the state must overcome for the documents to be admissible. Even if there is an exception for one level of hearsay, there is no exception for the second level of hearsay. So there's double hearsay here, right? There's the hearsay of the grandchildren saying what Donna Adelson told them, and then there's also the hearsay that Dan Markel is writing in his filings. In Nowak versus State, the court reversed the defendant's second-degree murder conviction where the trial court permitted the detective to testify to what a co-defendant said the defendant stated about shooting the victim. So this is a statement that the defendant purportedly said to the co-defendant. The court recognized that when the defendant said what the defendant said to the co-defendant was an admission. However, there was no valid hearsay exception to allow the detective to testify as to what the co-defendant said to the detective. The state has previously argued that Mr. Markel's statements in the court file were not hearsay pursuant to Section 90.801 Florida statutes because they are not being admitted for the truth of the matter asserted, but rather go to the defendant's motive. So this is what the court previously already ruled, that Dan Markel's statements in the court file do come in, even though they're hearsay, because they're not being admitted for the truth of the matter of what's asserted in those statements, but rather to show the defendant's motive. Simply stated, the statements go to the state of mind of the listener. So the meaning that what Dan Markel put in his motion, in his filings, the court is saying that would then provide a motive for Donna Adelson, but only if Donna Adelson actually knew what he put in those filings. Now, whether she did know it or not, that could be a question. Maybe that can be explored. But at this point, we don't really know officially. Definitely, there's no evidence that Donna Adelson actually said that she knew what was in those court filings. We haven't heard any evidence of that just quite yet. So this is about the state of the mind of the listener. In such circumstances, statements by Mr. Markel in his counter motion and other filings would not be hearsay to establish Mrs. Adelson's state of mind if the state can establish Mrs. Adelson knew the statements had ever been made. Now, everyone's thinking, yeah, she for sure knew what they were said, but you need evidence of that. Absent evidence establishing Mrs. Adelson was aware of Mr. Markel's March 26, 2014 counter motion, the state cannot admit that motion as substantive evidence in Mrs. Adelson's trial. So this is a very interesting and novel approach that these new attorneys are filing on behalf of Mrs. Adelson. After all, they're claiming that there's been no evidence that she knows anything about what's going on in the court filings. Now, between you and me, did she probably know? Most likely. Right? She was very on top of what's going on with Wendi Adelson. She probably knew very well. But the argument here is that until the state can establish that Mrs. Adelson knew about those court filings, they cannot be admitted to show her motive or her state of mind because she didn't even know about it. That's the argument that they're making, a very interesting argument. This was just filed today. We'll have to see what the state responds to this motion to limit, but I thought it's very interesting to hear about the different arguments about hearsay and about whether this goes to state of mind, a motive if it's going to fit into an exception of the hearsay rule, and also interesting to see how they how they classify that divorce, that it wasn't a bitter custody battle. It was just simply two professionals who decided that it's time just to get divorced. And obviously they have children involved, so they have to figure out what to do with the children. That's how they're going to try to explain this divorce, apparently. But I think a lot of people have feelings otherwise about what was going on with this divorce. So interesting motion that was filed. We'll have to see what the state responds, but I wanted to keep you up to date. This was just posted today on the docket, so I am even keeping track of some other cases as much as I can. But that is going to be it for the Donna Adelson news today, and we will see you at the next video. So until then, have a good one. And if you haven't yet, subscribe, like, and we will see you next time.